We are live, sir.
Greetings and welcome to Anekdhara's webinar. This is the 46th webinar. As all of you are aware, today's theme is judges appointing judges, India's controversial collegium system, and the speaker is Mr. Suhrit Parthasarathi. To anchor and moderate the discussion today, we have with us a very young and accomplished legal professional, whom I have the honor and privilege of introducing, Mr. Arun Menon. Mr. Arun Menon is a lawyer practicing before the courts and tribunals across Delhi. He is an alumnus of National Law University, Delhi. He completed his Master's of Law program at the University of Chicago, where he primarily read constitutional law and theory, following which he was admitted to the New York State Bar, which is a great accomplishment. He has practiced for over 9 years, predominantly in the areas of competition law, criminal law, both white collar and violent crimes, and has shifted more recently to civil public commercial disputes. He has a keen interest in constitutional law, particularly in the areas of government structure and judicial review. So it's a pleasure to have him with us to moderate the discussion today. The floor is yours, Arun.
Thank you. Thank you for that kind introduction and for organizing today's webinar. Good morning, everybody tuning in on a rather pleasant Sunday morning. On behalf of Anekdhara, I'm delighted to welcome you all to today's discussion on a topic that's not nearly spoken about enough. For the viewers logging in for the first time, a quick introduction on the organizer. Anekdhara is a public policy portal set up in 2021 by a group of retired civil servants with a shared progressive outlook and a fidelity to our constitutional values. The main objective of Anekdhara is to encourage discussion and discourse on topical issues and public policy matters. They have done this remarkably well, if I may say so myself, by hosting monthly webinars across a diverse range of subjects with a variety of domain experts. The subject of today's discussion is situated at the very heart of constitutional governance. For over 3 decades, judges of the India's higher judiciary, that is the Supreme Court of India and the 25 high courts across the country, have been appointed by the judiciary itself through what is known as the Collegium, a body comprising the Chief Justice of India and 4 senior judges of the Supreme Court. This system of appointment is not found in the text of the Constitution. Instead, it is premised entirely on the interpretation of the Constitution by the Supreme Court itself. On the face of it, the logic is rather simple. To preserve judicial independence, allow judges themselves to decide who joins the judiciary. In reality, however, this logic has generated one of the most enduring constitutional debates of our time. Proponents of the Collegium System see it as a shield against political interference, as a guarantor of independence. It is seen as a system which addresses the concern that judges appointed through political processes might feel obligated to reciprocate favors. Supporters also suggest that this system of selection ensures that appointments are based on professional competence, integrity, and legal acumen, instead of political considerations. Critics, however, see this as a system that has been arrogated unto itself by the Supreme Court by judicial pronouncement, shrouded in opacity and lacking completely in accountability. The issue today is as relevant as it's always been, perhaps even more so. The most recent example of the Collegium's functioning being highlighted or taking center stage concerns the appointment of a judge to the Supreme Court who is set to become the Chief Justice of India in 2031. It was reported that one of the Collegium's members registered a dissent against the candidate's elevation. We, however, neither know the contents of the dissent nor the factors that weighed in the minds of the other 4. It's important to bear in mind that the issue here is perhaps less about the candidate or an individual candidate. We've had fantastic judges, but more about the lack of transparency. It cannot be overemphasized that this is not an abstract issue or an exercise in theoretical exploration. Appointments to the higher judiciary have an immediate consequence, primarily for public trust in our system of justice, but also for the legitimacy of judicial review. Unlike the legislature or the executive, the people have no say, either directly or indirectly, over the appointments process. People in India have a right to decide who governs them, but they have absolutely no role in deciding who gets to judge them. To such a person, to my mind, there is little difference between a king who asserts his divine right to judge and a Supreme Court that asserts it knows best. The most recent attempt at reforming the system by way of constitutional amendment was struck down by the Supreme Court, only for the reason that it promised to threaten, or apparently promised to threaten, the independence of the judiciary and open it up impermissibly to influence by the executive. The reality, however, remains. The functioning of the collegium system is shrouded in mystery. While it is true that the collegium publishes its decisions, which is relatively a recent practice, it is also true that the decisions are taken behind closed doors. The system of appointments rests almost entirely on secrecy. The internal functioning of, or the thinking of, the collegium remains inaccessible. This also assumes significance when you consider that the collegium is also responsible for transfer of judges among the high courts. To take a recent example, since March, there have been the collegium has recommended the transfer of over 10 judges in and out of the Delhi High Court. Yet the reasons instigating such recommendations remain unknown to stakeholders, the lawyers, the bar, the litigants, none of whom are invited to participate in this process. Suggestions so far of any alternative system have, to my mind, to an extent, legitimately raised concerns or fears of politicization. The fundamental question then is, how do we ensure judicial independence while also balancing democratic accountability in a country as large and diverse as India? Now, to guide us through these issues, we are fortunate to have with us Mr. Suhrit Parthasarthi. Suhrit practices as an advocate at the Madras High Court in Chennai. He holds a degree of law from National University of Juridical Sciences, Kolkata, and in journalism from Columbia University, New York. He has written extensively with erudition and clarity and has contributed chapters to many books, including Dignity in the Legal and Political Philosophy of Ronald Dworkin, Appointment of Judges to the Supreme Court of India, Transparency, Accountability, and Independence, both published by the Oxford University Press, and To Incomplete Justice, the Supreme Court at 75, published by Jagannath. He has also co-authored the book M.K. Nambiar, a constitutional visionary, with the former Attorney General for India, Mr. K.K. Venugopal, published by Penguin. Suhrit is a regular contributor to the op-ed pages of The Hindu, which is where I first saw his writing over a decade ago. His writing has appeared, among other places, in the Hindustan Times, the Indian Express, Economic and Political Weekly, and on websites such as the New Yorker, New York Times, and ESPN Info. Few individuals would have studied the present subject quite so closely and consistently as Suhrit. A quick word on the format. Our session today will begin with Suhrit's address on the subject, followed by a round of question and answers. I encourage you to listen carefully and critically and drop any question you may have in the comment section. This is a rare opportunity to engage directly with one of the most thoughtful voices on the subject. With that, it is my privilege to invite Suhrit to deliver his address on Judges Appointing Judges, India's controversial collegium system.
Thank you. Thanks very much, Arun. Good morning to one and all. It's a great privilege to be with all of you here today. And I thank Anekdhara for organizing this and for giving me this opportunity to address such a distinguished audience on a subject which I think is of substantial importance to our democracy. That is the process that we follow to appoint judges to our high courts and the Supreme Court. And importantly, also the process we follow in transferring judges between high courts, a feature, as Arun just explained, that's been increasingly used to apparently further the administration of justice, but which has been implemented with little in the way of transparency. The process that we follow has come to be called the Collegium System. It's a unique, peculiarly Indian mechanism through which judges appoint judges. It is a system that wields enormous influence over our constitutional republic. Because in a democracy where judges and where the courts serve as virtually the final avenue of review of any state action, how we select our judges is a matter of seminal significance. Today, at least on the face of it, it is this collegium which decides who sits on our high courts and on the Supreme Court, and therefore gets to decide who decides the great questions of our time. Yet, for all of this power that it enjoys, the collegium functions in near complete darkness. It is opaque, mysterious, and virtually inscrutable. My plan over the course of this talk is to walk through 5 areas broadly. Firstly, the origins of the supposedly consultative model in the Constituent Assembly debates, and how, therefore, the text of the Constitution was intended to constitute a balance. Second, the shift over time to the present system of appointing judges, particularly through what has come to be called the first, second, third, and fourth judges' cases. Third, the practical problems that have arisen as a result of this system, the lack of transparency, the informal selection criteria that is followed, executive friction, and broadly how the system deeply impinges on diversity on the bench, on the manner of choosing our judges, and ultimately on the decision-making process. Fourth, why this transformation matters for judicial independence, the idea of counter-majoritarianism, and the balance of power in the larger separation of power that the Constitution seeks to put in place. And finally, how we've consistently chosen to ignore the warning signs of the past through a persistence with a system that is plainly anti-democratic. So let me begin with the Constitution itself and its framing. The Indian Constituent Assembly, and this has been documented, for example, in the historian Granville Austin's works, possibly spent more time deliberating how to establish an independent judiciary than over any other point of contention. This was because the framers did believe that it was only a judiciary that was properly insulated from the other wings of government, the legislative and executive wings, that could truly guarantee to the Indian people the sort of social revolution that was envisioned in the Constitution, that the Constitution was always meant to usher in. But while judges had to be sequestered from political influence, at the same time, the framers also found it imperative that there were sufficient checks and balances that were installed within the text of the Constitution and within the larger constitutional vision to ensure that the judiciary was accountable to the Indian people. But ever since, and this is just again by way of an overview before we get into the framing of the text itself, we know that ever since the Indira Gandhi government launched a withering attack on the judiciary in the 1970s, India has been appointing judges to its higher courts through a process that in one way or the other, either with the collegium or even before the collegium, has undermined the consultative principle on which the text of the Constitution is rooted. And this in turn has played out as part of a larger, longer running battle over who should ultimately control the Constitution, whether it should be the Supreme Court or Parliament or the executive. In the current system that we have in place, at least since the early 1990s, a changing group of 5 judges, headed by the Chief Justice of India and known as the Collegium. And in the case of the appointments to the High Courts, it's the Chief Justice of India with his 2 senior-most colleagues, who effectively control appointments and have usurped the power that almost entirely lied with the executive through a series of questionable rulings, in which we'll come to again. Now, as a result of all of this, the Indian public really knows very little about the 33 men and 1 woman who currently serve on the Supreme Court, or about their recent predecessors, Now, even less is known about our High Court judges. There simply isn't the space for a larger democratic debate about the criteria on which judges ought to be selected. But how is all of this placed in the larger theory that the Constitution sought to envision? Now, we all know that the basic theory of a tripartite separation of powers between the legislature, the executive, and the judiciary was possibly first put forward in the 18th century in categorical terms by the French philosopher Montesquieu. Now, this theory broadly asserts that the autonomy and independence of the courts will serve as the best and greatest protection against the tyranny of the majority and against any person in a position of power who seeks to treat rights as fungible objects, as something which are easily assailable. Now, it is in keeping largely with this view that the framers of India's constitution saw the judiciary as the primary guardian of the sort of equality, both political and civil, as well as social, that they sincerely hoped that independence would usher in. And it is to that end that the Constituent Assembly, in the first place, vested in the Supreme Court and the various high courts the power of judicial review, which allows the courts to strike down even laws of parliament. In India, unlike in Britain, parliament by itself isn't sovereign. If parliament makes a law, or if one of the state legislatures makes a law which runs contrary to the constitution, then the judiciary is vested with the power to strike this down. And this sort of forms the fundamental basis for the separation of powers that the constitution seeks to put in place. But the difficulty when it came to deciding how judges are to be appointed is that, and history really shows us this, is that there is no perfect way to create an ideal separation of power or a sort of a perfect antidote to majoritarianism. In the United States, you had the legal scholar Alexander Bickel, who wondered how judicial members who are unelected could exercise the sort of vast powers that they do and enjoy almost an unimpeded authority in reversing decisions taken by the political executive or by a democratically elected government. Now, checks and balances there were meant to come in through a selection process which would ultimately be subject to confirmation by a legislative body. But in practice, as we know, the government in power, even in the US, often elevates judges who are closely aligned to the ideology of the ruling party. And broadly, history has shown us that judges tend to interpret the law in ways that are sympathetic to the worldviews of the legislature and the executive at the time. And indeed, in 1957, the American political scientist Robert Dahl wrote about how it was simply unrealistic to expect members who are recruited in this fashion to the Supreme Court to hold against the government of the time or to hold norms of rights or justice to be critical in this process of judicial review. But to ensure separation of powers, to protect the judiciary from other wings of government, what the constitution's makers in India did was that before they got into this process of deciding how to appoint the judges, they introduced several other key provisions. And these are all important for us to bear in mind when we also consider how we appoint our judges. For example, the Constitution provides that salaries and allowances of the judges are to be charged only from the consolidated fund of the state, that each of the high courts and the Supreme Court would have the power to punish for contempt of court. And of course, as we've also seen in some debates recently, how judges of both the Supreme Court and the High Courts can only be removed under any circumstance through an improbably onerous process of parliamentary impeachment. But ultimately, when it came to deciding how we appoint our judges, the drafters saw the vesting of this authority in the judiciary as conflicting with basic constitutional norms. There was intense debate on where that authority should be vested. One member of the assembly, Shibban Saxena, suggested that judicial appointments ought to be confirmed by at least a two-thirds majority of both houses of parliament. Another member, B. Poker Saib, suggested that a judge of the Supreme Court ought to be appointed only after securing the concurrence of the Chief Justice of India. Both of these suggestions were rejected. The broad feeling of the assembly was that involving the legislature in the appointment process would be cumbersome and it would undermine the dignity of the judiciary. And also that to accord the Chief Justice of India a kind of a veto over appointments would be plainly anti-democratic. Therefore, in Dr. B.R. Ambedkar's words, the Constitution ultimately decided to tread a middle course. And it was after this sort of substantial debate that Article 124 of the Constitution was drafted. And it stipulated that the president would appoint judges to the Supreme Court after consultation with such of the judges of the Supreme Court and of the high courts in the states that the president thinks necessary. And where the appointment is of a judge other than the Chief Justice of India, the president would also consult the Chief Justice. In similar vein, Article 217 speaks of appointments to the high courts, and once again the president is vested with his authority, but to do so after consultation with the Chief Justice of India, the governor of the state, and in the case of appointment of a judge other than the Chief Justice of that high court, the Chief Justice of that concerned high court. And again, in similar lines, Article 222 vests the power to sanction decisions on transfer of high court judges on the president. But he or she is required to compulsorily consult the Chief Justice of India as a prerequisite to any order of transfer. Now, when we look at the text itself, it seems simple enough. We all know that the president acts solely on the aid and advice of the Council of Ministers. So what was in fact written into the Constitution was a pure executive power, but it was to be exercised by consultation. And the word consultation partakes an enormous significance, and it would come to dominate debates over the appointing process in the years to come. Now, usually popular discussions on the textual interpretation of these three articles, they usually tend to begin with the Supreme Court's decision in S.P. Gupta versus Union of India, a case that is often described as the first judge's case, which was delivered in 1980-81. But really, there was a case before S.P. Gupta where the Supreme Court took large pains to describe or to construe the word consultation, which is used in these provisions. This is the case of Sankal Chand Himatlal Sheth. Now, the background and the facts of the case leading up to Sankal Chand Sheth's case in the Supreme Court are quite interesting. And they illuminate the divide between the executive and the judiciary over the maintenance of the independence of the courts. Now, in 1975, soon after Prime Minister Indira Gandhi had declared emergency, we all know that several hundreds and thousands of people were arrested under the draconian Maintenance of Internal Security Act. Their fundamental right to life and personal liberty was suspended. But when some of the judges of different high courts challenged the government's sort of brazen, almost dictatorial exercise of power, the state responded with tyranny. It sought to transfer as many as 16 judges who had ruled against the government between the various high courts. One of them, Justice Sankal Chand Sheth, who had been transferred from the Gujarat High Court to the Andhra Pradesh High Court, challenged this order of transfer. And his case ultimately reached the Supreme Court, and in many ways that might well be described as the first judge's case, but leaving that aside for the time being. It was a case which reached the Supreme Court, and it was perhaps the first time where the government at the time and the judiciary came into conflict over how the court would be composed. In its decision, the court ruled that the Chief Justice of India's opinion over any proposed transfer of a judge from one high court to another was not binding on the executive. The word consultation, which was used in Article 222, the court held, had to necessarily be interpreted literally. In other words, that consultation can never mean concurrence. But at the same time, and this is an important caveat that the Supreme Court placed, which is that the court also found that the government could eschew the Chief Justice's opinion only in exceptional circumstances. That is, according to, and this was a judgment written by Justice V.R. Krishnaiyer, he said this process of consultation has to be real, substantial, and effective, and it had to be based on full and proper materials that were placed before the Chief Justice by the government. So if the government had to then depart from the Chief Justice's opinion, according to Justice Krishnaiyer, such a departure might well have been subject to strict judicial review. So they would have had to have put their decision in writing as to why they were departing from the opinion of the Chief Justice and taken a calculated view on the matter rather than it simply being a matter of discretion. But no doubt consultation would not mean concurrence, but the government would have to have really good reasons for why they're departing from the Chief Justice's opinion. But in 1981, when S.P. Gupta was decided, and this is often described as the first judge's case, the court was called upon once again to specifically interpret the meaning of the word consultation, which is used in Articles 124 and 217. But the difficulty in this judgment of 7 judges is that the court only partially adopted the logic deployed in Sankalchan Sheth's case. The court agreed with its earlier decision that consultation could never mean concurrence. And therefore, the president, acting through the Council of Ministers, effectively had the power to completely disregard the Chief Justice's opinion. But the difficulty here with the decision in S.P. Gupta was that it simply didn't adopt the various other caveats that Sankalchan Sheth had put in place. And it toppled the matters almost completely in favor of the executive. So the balanced position that Sankalchan Sheth embraced was effectively discarded. Now, for quite a while thereafter, a number of appointments, especially towards the latter part of the 1980s, were made by the executive without obtaining the concurrence of the Chief Justice of India. I mean, he was consulted in name, but there was no real proper consultative process that was being followed, and the Chief Justice's opinion was being discarded for the asking. It was in this context that the Supreme Court decided to reconsider its decision in the first judge's case, in what is known as Supreme Court Advocates on Record Association versus Union of India, a judgment delivered in 1993. Now, this is the second judge's case. Here, in nine-judge bench of the court, what it did was it went to another extreme. Instead of adopting the sort of balanced line that was used in Sankalchan Sheth's case, it made a dramatic departure from the reasoning in the first judge's case. No doubt there were several sermons on the concept of independence of judiciary and how it's important to democracy and so on and so forth that the court wrote about. But it ultimately ruled that the word consultation in Articles 124, 217, and 222 denoted concurrence, and that the primacy in making judicial appointments was therefore vested in the office of the Chief Justice. The court also ruled, once again with little basis in the Constitution's text, that the Chief Justice was now required to consult with 2 of his senior-most colleagues, and the most senior judge of the Supreme Court, whose view was likely to be significant in adjudging the suitability of the candidate before making any recommendations. Now, it is this body that we now call the Collegium. This was expanded, as we saw earlier, to a body comprising the Chief Justice and his 4 senior-most colleagues in the case of appointments to the Supreme Court by the third judge's case. But ultimately, what the court felt was that if the judiciary had to be truly independent, the Constitution had to be read and interpreted in a manner that would ensure that independence. And therefore, consultation has to be read to mean concurrence. and any other reading would simply go contrary or run athwart the Constitution's broad vision. So, in one fell swoop, really, the Supreme Court completely refashioned the process of appointing judges to India's higher judiciary. It removed the primacy that had been explicitly bestowed on the executive by the Constitution. We saw the debates in the Assembly, how placing primacy in the Chief Justice was a suggestion made by one of the members in the Assembly and was explicitly rejected, and that it was thought that it must lie with the executive. But this system, and we'll come again to this in a little more detail later, which the second judge's case put in place, has not only proven ineffective in its ability to improve perhaps the quality of the court, but it's also intrinsically anti-democratic because the court was effectively rewriting the Constitution. It was altering the literal meaning of the word consultation and deeming it to mean concurrence. Now, since then, the Collegium has proliferated a large set of criteria that are not really written anywhere. There is apparently something called a memorandum of procedure that exists, which is called as an MOP, which determines how judges will be selected. But this is, again, we are in the realm of conjecture here. But what we know is that since the system has come into force, I don't think any person below the age of 55 has been appointed as a judge of the Supreme Court. In fact, since 2009, a substantial number of appointments have been made where judges have already turned 60. And this is significant because judges of the court are constitutionally required to retire at 65. Then the other sort of considerations come into how judges are chosen to the Supreme Court, especially. Geographical variety is favored over other factors, including gender, caste, and religion. No more than 2 or 3 judges from the same High Court serve together on the Supreme Court at any given time. Questions of an individual's candidate's overall suitability, his or her character, his or her legal acumen, etc., don't seem to necessarily play a part in the Collegium's informal criteria when it comes to selecting judges. These are often overlooked for other factors, such as I said, geographical variety. And there's a serious cloak of, there's a cloak of secrecy that surrounds the discussions of the Collegium. The criteria that it employs is kept completely outside the scope of democratic deliberations. And the body effectively functions as though it is answerable to nobody. But, and we'll come to this again in some time, we'll also sort of see how the executive has been able to play around this cloak of secrecy and in fact assert its own dominance in many ways. But after this, once power changed again in 2014 and we had a new government come into force, a newly elected NDA government with Prime Minister Narendra Modi at the helm, who had won a large majority, the Parliament once again sought to reassert executive supremacy over the appointment process. And it introduced the 99th Amendment to the Constitution and created something called the National Judicial Appointments Commission. But what the government possibly didn't realize at the time, and perhaps it's since been realized, is that the collegium system in fact doesn't in any manner seriously hamper the executive's ability to wield almost a silent control with insufficient public gaze over the process of appointing judges. But before we get to that, just to briefly study the 99th Amendment, and I personally thought that the amendment in paper was something that ought to have been considered workable. It provided a reasonable solution to curing some of the problems in the extant system. Now, the 99th Amendment introduced 3 new articles into the Constitution. Article 124A, which sought to establish a 6-member Judicial Appointments Commission. This would have comprised the 3 senior-most judges of the Supreme Court, including the Chief Justice of India, 2 eminent persons, and the Law Minister. Now, Article 124B sought to grant to this commission the absolute power to make appointments. And 124C also provided Parliament with the power to make laws to regulate the procedure for appointment of both the Chief Justice of India and other judges of the Supreme Court and the various high courts. The read together the NJAC Act, which they enacted pursuant to this power vested in Parliament through Article 124C, and these three amendments read together effectively sought to consign to the ash heap of history the Collegium System and infuse into the process of appointing judges possibly greater transparency and more democratic accountability. But these three articles and the ancillary legislation were immediately put under challenge in the fourth judge's case. Various petitioners argued before the Supreme Court that the 99th Amendment and its provisions and the NJAC Act infracted the Constitution's basic structure and was therefore void. In essence, what the petitioners submitted was that because the Supreme Court had held in the second judge's case that the vesting of primacy in matters of appointments to the judiciary with the Collegium is a part of the Constitution's basic structure, any amendment that sought to destroy or remove the Collegium's primacy would therefore become a nullity. This case was heard by a bench of 5 judges, and each of the judges wrote a separate opinion. There were opinions from Justice Kehar, Justice Lokur, Justice Joseph, Justice Goel, and a dissenting judgment from Justice Chalameshwar. Now, we know that Article 368 of India's Constitution grants Parliament a virtually plenary power to amend the Constitution. But in 1963, in the famous Keshavananda Bharati case, through a slim 7-6 majority, the Supreme Court had ruled that this power had in it certain implied limitations and that the Constitution could not be amended in a manner that destroyed or infracted the Constitution's basic structure. In this fourth judge's case, the Supreme Court, 4 out of the 5 judges held that the 99th Amendment violated the Constitution's basic structure and was therefore null and void, and that the Collegium system would have to continue to serve for the present as it established primacy in matters of judicial appointments in favor of the Chief Justice of India and his senior-most colleagues, and therefore preserved judicial independence. Now, on a reading of this judgment, it's very difficult to understand the precise sort of manner in which the judgment was arrived at. And it's very difficult also to say which of the 4 judges' opinions constitutes the majority's leading judgment. But what we see is that the broad agreement between the 4 judges in the majority is that granting primacy to the Collegium ensures judicial independence. And by itself, this primacy is a part of the Constitution's basic structure. So, while we saw in the second judge's case, the Supreme Court had interpreted the word consultation to mean concurrence, there was in fact nothing in the judgment which also suggests that this primacy that arose out of such a reading was so high as to be a part of the Constitution's basic structure and almost untouchable. Now, it's no doubt possible that the majority in the second judge's case felt that, in their opinion, according primacy to the Collegium would serve judicial independence well. But I don't think it follows as a necessary sequitur that the removal of this primacy violates the Constitution's basic structure. But in any case, the Supreme Court in this 4th judge's case thought differently. But even though they don't point to any particular portion in the earlier judgment which makes such a claim. Now, the result of this conclusion is this: an extra constitutional method which has been devised by the Supreme Court on its own to appoint the court's members is now considered to be so intrinsic to the Constitution as to be incapable of being amended. The decision, therefore, acquires an entirely political character, and it effectively erodes the democratic legitimacy of the Supreme Court's power to review constitutional amendments on the grounds of the basic structure doctrine. Now, as we've seen earlier, the Constituent Assembly had very carefully considered the wordings of Articles 124 and 217, and they were in many ways dismissive of the very idea of granting primacy to the judiciary. According a prerogative to the executive in these matters was not seen as anathema to judicial independence in any way, but was almost seen as an essential precondition to the guarantee of a proper separation of powers. So when we consider the fact that the Constitution itself explicitly placed overriding power on the executive to make judicial appointments, it's rather difficult to see how a proposed system which accords the judiciary not merely a consultative role, but a determinative one, can be found to infringe the autonomy and independence of the judiciary. Now, the fear that the executive might well use the authority vested in it to appoint blind judges, etc., is not necessarily unfounded. But the National Judicial Appointments Commission, which the 99th Constitutional Amendment sought to enforce, did not permit such excessive authority. It was a six-member commission, once again tilted in favor of according the judiciary a significant say, because it comprised the three most senior judges of the Supreme Court. It also accorded the Chief Justice of India a vote in determining the two eminent persons to be nominated on the commission. And if Parliament, ultimately by law, were to modify the mode of the Commission's workings in a manner that impinged on the judiciary's independence, the Supreme Court would have always been free to declare any such legislation void. The other option that the court also had, and which it did not sort of choose to do, was to read down the amendment and possibly retain some amount of control over the process of appointing judges, while not altogether sort of throwing it out and holding it to be in violation of the basic structure. So when it delivered this ruling, the Supreme Court in 2015, it effectively described its ruling as a reaffirmation of judicial independence. And at that moment, many believed that we had returned to this sort of high ground of judicial autonomy. Judges would select judges, independence would be secured. But now here we are sort of more than a decade later, and the reality looks very different. I think almost counterintuitively, the NJAC judgment has not so much strengthened the judiciary's hand, and in fact, quite to the contrary, it has weakened it. And now, why do I say this? Because the Collegium and the manner in which it's functioned after 2015 is more vulnerable than ever to executive obstruction. Today, the government doesn't need to confront the Collegium openly because it does things which are a lot subtler. It simply doesn't act. For example, a recommendation goes from the Collegium to the government. And if the government doesn't want to act on such recommendation, it either keeps the files with it, it keeps the names pending, months pass, in some cases, years pass. And in some cases, the government returns the file for reconsideration. And there, when the matter goes back from the Collegium to the government saying, no, we believe that this name has to go through. And as per the judgments of the Supreme Court, on such re-recommendation, the government has no choice but to grant its imprimatur. The government again simply sits on the file. Then what happens? Matters are moved before the Supreme Court, but who are you going to hold in contempt here? So, judges reach retirement age sometimes before their files are cleared. Vacancies pile up. Entire high courts sometimes run at half strength. So in this sort of quiet way, the executive almost exercises a de facto veto. So paradoxically, a system which is designed to protect independence has created a structural opportunity in many ways for obstruction. And this is compounded by the Collegium's own secrecy. Reasons are not published. There was a brief effort made at putting forth some reasons on the court's website. But criteria is not clear. The executive can cherry pick. It can say that we have concerns about integrity or there is an adverse IB report. But none of this is known to the public. A single sort of leak to a newspaper can derail a name. And the only way in which the Collegium seems to function is through such leaks, really. Opacity was supposed to insulate judges, but in practice, opacity has left them exposed. And this has led to sort of a peculiar imbalance. In formal terms, the judiciary has primacy. As interpreted in the NJAC case, the Constitution tells us that appointments are the court's domain. But functionally, the executive has learned over a period of time, and this is not just since 2014, but this goes back to the days preceding the NDA government's time, where the executive has really learned how to control the pace of making appointments, the timing of making appointments, the outcome of these processes. So it's almost like a seesaw where one side holds the rules, but the other side controls the movement of the seesaw. The Collegium recommends, the executive delays, the Collegium reiterates, the executive still delays, and in the meantime, the system simply bends and there is no accountability at all. And all of this matters greatly simply because the stakes are so high. And we know that judicial independence is critical to the maintenance of democracy. It acts as a guarantee that when the state overreaches, when rights are curtailed, when dissent is silenced, when laws encroach on liberty or equality, that there will be an institution that is capable of reviewing such state action. But if the pipeline of appointing judges itself can quietly be shaped by delay and veto, what real independence would the judiciary continue to have? So ultimately, for an independent court, we need more than just simple rhetoric or indeed this collegium system. We need to ensure that appointments are timely, transparent, and entirely insulated from hidden interference. But to return to the irony for a moment, in 2015, the Supreme Court struck down this system that gave the executive a seat at the table. It said that, look, you're here, we'll have this broad consultative process. But in the years since, by clinging on to this sort of almost secretive collegium system, the court has opened the door for the executive to exercise influence in more informal and less visible ways, and almost therefore in more dangerous ways. So I would say that the NJAC judgment, far from entrenching independence, has created conditions where the executive's say today is greater than before. Not so much through constitutional design as much as through constitutional dysfunction almost. The lesson here is stark, and this leads me to my conclusion. Judicial independence, I do not think, can be preserved by secrecy alone. We live in a culture of justification. Our democracy rests on a culture of justification. And in a culture of justification, and this is a principle that the judiciary itself has invoked in the past to demand accountability from the state. It is the cogency of the reasons that are offered that will always have to be tested. But when it comes to the court selecting its own members, it appears that we do not have any right to know. And there's total opacity. For example, we saw in the most recent appointments that were made to the Supreme Court, one of the judges on the collegium purportedly dissented. But we learn of this dissent only through reports in the press. And what exactly that dissent note contained, we do not know. We're told by the press that the reservations that were contained in the dissent note were grave. But it's also unclear whether that dissent note was even shared with the union government, which within 48 hours, within 2 days of the recommendation being made, went ahead and notified the appointment. The other big problem, and this is something that Arun had highlighted during the course of the introduction, is the problem with transfers. High Court judges are almost treated today as though they're members that are amenable to oversight by the Supreme Court is not in any manner superior to the High Court judges, right? They're meant to be equals. The Supreme Court enjoys appellate power over High Courts, but they do not exercise any supervisory control in the manner in which the High Court enjoys over the subordinate district judiciary. But judges are transferred into, say, courts. We do not know the reasons for these transfers. One sometimes wonders, and one of the judges said so himself in a farewell speech, that he himself didn't know why he had been transferred. So, this entire opacity that prevails over this system is something that must be broken. There has to be a solution to this, and the solution lies within the collegium needs to function in a manner that where it puts forward its criteria clearly. There are systems that have worked well in other jurisdictions. You have Judicial Appointments Commission in the UK and in South Africa, where you have a large cross section of society coming together. The process of appointments is performed through a process where people willing to undertake judicial service apply for those posts. These posts are advertised. There's a clear criteria that is fixed. There is then perhaps a written test, there's an interview process, and there are clear guidelines and guardrails that are placed. And there's nothing to suggest that such a process should not work in India. Maybe some of the critics were correct in that the National Judicial Appointments Commission wasn't a perfect composition. But that doesn't mean that we need to stop thinking along those lines and think of a more broad-based commission that will ensure that transparency is achieved and that ultimately we get a judiciary that is truly independent. Thank you.
Thank you, Suharit. That was, as ever, a thought-provoking, insightful address. You outlined the issues that is prevailing in the system today, and also how we've come to this position. Now, if we were to take up questions, I had one. What do you think of the logic, and is there a logic that today Parliament retains the ability to impeach judges? So while appointment has been assumed by the judiciary, removal still vests with the legislature.
Yes,
Is there logic there? And second, if an impeachment were to go through, would that be subject to judicial review? Do you foresee a situation where even that power is kind of taken by the court?
look, I think everything is subject to judicial review. To answer your second question, second part of your question first. So I don't think it's more a question of standards of judicial review, because even constitutional amendments, as we know in India, are subject to judicial review. But the question of how deep the courts would look into such a eventuality, if and when it were to occur, is something where the court would have to grapple with the kind of scope that it needs to put in place. Because obviously, if a person or if a judge has been impeached, it's a matter of great gravity. And but at the same time, courts will have to be conscious of the fact that it cannot be stepping into the shoes of Parliament. It would broadly have to see if the procedure was followed correctly and if there was procedural due process that was in play. But look, I get where you're coming from in terms of whether removing judges being a function of Parliament is somehow contrary to the larger system when the process of appointing doesn't vest with Parliament or the executive. But that's precisely why the Constitution's makers thought it necessary that the power to appoint should also vest with the executive, and the power to remove should vest with Parliament, and it should be an onerous power, because there's no other way to ensure judicial autonomy. If judges can be removed for the asking, then you're not going to have independent judges who are capable of standing up to government, who are capable of ruling against the government of the day, whether it's on the laws that are made by Parliament or on the actions of the political executive. So, the reason why impeachment was seen as the only mode for removing judges was to ensure that we had an independent judiciary. Whether it's worked in practice, whether we need to have, other kinds of if not process of removals, other kinds of disciplinary mechanisms, is something that we all need to debate and ponder over. It is certainly a concern, and I think this argument has been made many times previously, that having such an onerous process has also meant that other aspects which are antithetical to our proper democratic function have been compromised. We might have cases where you have either a corrupt judge or a judge who's indulged in some other sort of misconduct, who simply cannot be removed from office because of the onerous nature of the process, who then is perhaps transferred from one court to another, which is simply not the solution. So yeah, we must think more deeply about how we can improve that process of removal as well.
Thank you. We'll be taking questions now from the audience. The first one is, how effective has the collegium system been in promoting diversity and representation in Indian judiciary, including gender, caste, and regional balance?
Yes, I don't think it's been very effective at all. I mean, gender we've seen even recently with the composition of the Supreme Court, and that 33-1 is then means that it's not been effective. And some of the former chief justices have said that this gender diversity would improve in over time because there are more women who've come into the subordinate judiciary. There have been more women judges appointed to the high courts, and therefore as they make their way up, the diversity on the Supreme Court would also improve. But I think there was nothing stopping from the court from making appointments of women to the Supreme Court over the course of the last 2 years or so. There were enough and more senior women judges who were available, but for reasons best known to the Collegium, and we would not know the reasons because these reasons are not made publicly available. That has not been done. Uh, and I think the same with respect to other aspects of diversity and representation as well. The Collegium does say that it takes into account these factors, but when it says it takes into account these factors, it doesn't quite clearly lay out how precisely it has taken into account these factors. It simply says it as a matter of routine and as a matter of course. Uh, but what are the various ways in which it is considered representation on the basis of caste uh, or regions is something that is again never really communicated to us. But I think studies are there which shows that on an overall basis, the courts are lacking in diversity.
Thank you. Next, we have, while there is a case for having the collegium system, how does such a system address the proximity of judges, particularly in the context of recent chief justices, proximity to leadership in power? Is there a provision in the collegium system to prompt this? I imagine this coming from Justice Chandrachud inviting the Prime Minister for a little prayer meet at his.
There is nothing in the collegium system which sort of speaks of this proximity or speaks to how this proximity has to be done away with. I think some of these standards flow from the Bangalore resolution of the early 1990s in terms of how judges are meant to conduct themselves, and those remain true to the date in terms of maintaining distance from the political executive, and I think that's part of the oath that a person takes when they assume judicial office. The collegium system, to answer the question as well and to place the question in slightly broader terms, doesn't really address any issue at all. It simply says that in making appointments to the higher judiciary, the recommendation will come from the collegium. So to just explain the procedure broadly, let's say that uh, appointments are necessary in a high court where there are vacancies. The Chief Justice of that high court would consult his or her colleagues and would finally consult his or her two senior most colleagues and would then come up with a list of names that they wish to recommend. Then those names would then go to the government, would get both the state and the center would be cleared for the reports would be placed on these names, and that would be placed before the Supreme Court's collegium. So in this case, the Supreme Court's collegium would comprise the Chief Justice of India, his two senior most colleagues, and the senior most judges from that high court to which the appointment is being made would also be consulted. And then they would come up, they can either choose to send the entire list back, or they could say that, there is these many, these people are amenable, they are capable of being serving as judges in the high court, so therefore we recommend them. And they send that recommendation to the government of India, which then would either say yes or return the names for reconsideration. And I'm talking here purely in terms of how the system is supposed to work in theory. And if the government has said yes, then the president appoints. If the government returns the names for reconsideration, the collegium can either choose to agree with the government's proposal, or it could send the names once again back to the government on a re-recommendation. And in theory, when the collegium sends the name back for reconsideration and says that these people ought to be appointed, the government has no say in the matter anymore. The executive is supposed to go ahead and make the appointment. So really, the collegium system, as was put in place by the second judge's case and affirmed later in the third and fourth judge's case, does just this. There is, as I also said during the talk, something called a memorandum of procedure, which supposedly kind of details the manner in which all of this has to be worked out, but it doesn't get into criteria. The criteria is fixed by the Constitution. There are informal criteria. For example, the Constitution doesn't have any age criterion. It simply says that one must have practiced for at least 10 years as an advocate or be a jurist of standing, etc. But where it says 10 years of standing, the collegium still has an informal criterion that only persons above the age of 45 would be appointed as a judge of a high court. But this is not written in the constitution anywhere. So there are a number of these sort of criteria that are laid down by the collegium itself, which are absent in the constitution and have no basis in the constitution's text. But to answer the question directly, there is nothing else that the collegium system really does.
Thank you. Now we have a question with some context, so bear with me.
Sure.
When people accuse the collegium system of being opaque, isn't that only a partial truth? After all, secrecy is deeply embedded in our own religio-cultural tradition, what Al-Biruni once called nigadli. Even the Bhagavad Gita, which is hailed as an open text of salvation, calls its wisdom Paramam Guyam, the supreme secret. Extending this from philosophy to politics, our government today claims the right to watch even citizens' private lives, while denying citizens the right to know what the government itself does, whether it's the Rafale deal, electoral bonds, or the legal immunity enjoyed by election commissioners. So, is it really possible to fight this opacity without challenging our larger culture of secrecy itself?
No, I don't think it's possible to fight this opacity without challenging the larger culture of secrecy at all. And I think this larger culture of secrecy has to go, which is why I think that we have to understand and realize that our democracy rests on a foundation which is built on a culture of justification. Like any governmental action is meant to be justifiable, and it has to be founded on reasons. We are really supposed to be, in theory and in paper, a republic of reasons, where every action of the state is reasoned, is based on, if not data, is based on a certain thinking, is with a view to achieving a certain objective. And when it comes to testing the actions of other wings of government, we've had the Supreme Court come up with theories, right? For example, back in the day, you had a theory of Wensbury unreasonableness, even to test on administrative action, where the idea was that as long as a governmental action isn't something which is considered is so unreasonable as to be something which a reasonable man would not consider unreasonable, then it's fine. But today we've progressed from all of that to something of a principle of proportionality, where a governmental action will have to be tested on the basis of its objective. You'll have to see if the action taken had the least effect on the rights of citizens. We'll have to see if there were other less intrusive alternatives that were available to the government in restricting a right, and various different objectives and rights will have to be balanced in this process. So when we have the judiciary coming up with theories such as this, which are built, of course, from influences from across the world, there's no reason why it must subject its own procedure of making appointments uh, to a larger culture of secrecy. Yeah, I think ultimately it must shed that cloak, and I agree with the person who's asked the question that uh, it's not possible to fight this opacity without challenging that larger culture.
Pulling on that same thread, given that the Supreme Court wields enormous power under Article 142, given a tendency of the court that we've seen to enter policy-making realms, where it's no longer interpreting the text of a law or adjudicating a particular set of facts before them. And when you consider that we have adopted ideas such as the proportionality test, which in the right context, it just appears to be an ad hoc assertion of what ought to be a result. Why do you think there is not a more pressing debate on this, not just among the people, but among our lawmakers? Why is this not something that NJAC was 10 years ago? It failed. But why is it that they have not come back with something to replace it or replace the collegium?
Yes, I mean, I think they've not come back with anything for purely practical reasons, because they find that this system works great for them, right? Like, in the sense that it works great simply because they're able to stall appointments, they're able to effectively ensure that names that are inconvenient to them do not go through. See, the system works in mysterious ways, right? Like, you could have a case where an a nomination is made for an appointment to the Supreme Court, which is cleared in 36 hours, 48 hours, sometimes within a day, you could have nominations made to the High Court where the warrant of appointment comes within a day or two. And then there are cases where this does exist, in fact, where people have been waiting for more than 2 years, where the recommendation is gone from the collegium, but the government is still sitting on the file. So the government knows that if it wants to, forestall an appointment, it can do so easily. So this gives to a culture of give and take, and a culture uh, where behind the scenes we do not know what is happening in terms of how what sort of criteria is employed, how our judges are being appointed or transferred at all, and therefore it is that there is an absence of political will. I think a political will exist or come into being only when there's really a broad necessity for it. Of course, there isn't a public pushback either because, ultimately this is not, while this is critical to how our democracy functions, it's not something that has subsumed political debate in any manner. And we've not even seen the opposition really take this up as a matter of concern in terms of how our judges are appointed. And perhaps it is something that is where everybody needs to be held accountable in terms of not taking this issue seriously enough.
Thank you. To the executive, judiciary, legislature, should we add a fourth feature of, say, an academic council whose role it is to bring in expertise? So instead of, maybe, if I understand the question correctly, it may be under the signature of these bodies, but finding the candidates, curating a list of candidates, we can outsource that to an independent company.
The court or the collegium is supposed to have a secretariat. And when the fourth judge's case was ultimately delivered, the court also said that it'll open up to the public for comments on how the collegium can be improved. And I think it also sort of appointed amicus curiae for the matter to sort of sift through these comments and see how the system can be improved. But nothing really came out of the process. It lost steam very quickly. And the collegium is meant to have a secretariat and have a repository of information and a body which will help study judgments. So, for example, like Supreme Court judges are very busy, right? Like it's in the sense that you're sitting hearing matters of serious constitutional importance. You're sometimes on miscellaneous days you're hearing 50 to 60 to 100 matters a day, and they simply cannot have the time possibly to sit and assess how high court judges are performing, the quality of the judgments that are being written, or assess the quality of various advocates who are under consideration for elevation. It's so there is no real forum today for that sort of analysis, and that needs to exist. So a good working system, I think, would be a commission which composes of certain judicial members, but also has a sort of a secretarial body which will sit and do this exercise. And perhaps there need to be certain retired judicial minds, who can be appointed to these uh, commissions in order to sit and perform this exercise, because it's not something that perhaps lay persons can really do. Although I think it's important to also have the say of the lay public, but it studying the quality of judgments written by, say, a high court judge might require a judicial mind. So it's something that we need to think deeply about.
Right. Thank you. Next question. Given that the collegium is of a compact size, is there a general rule or convention that the appointment shall be made on a general consensus within the collegium? Is there a known convention in this regard? If not, do you see merit in such a principle?
Right. So from my understanding, the original convention was that they would go on the basis of unanimity. And we've seen from reports in the press that in the absence of such unanimity, sometimes appointments have not happened to judges on the Supreme Court, especially. But it's clear now from the most recent episode that they perhaps do not go on the basis of unanimity, that all they need is a majority, really. And again, there is no known convention, really. This is all on the basis of what we've read about in the press. And So, for example, the recent appointment did not even contain in the publication of its resolution on the court's website the fact that there had been a dissenting note. Uh, so, therefore, it functions under such enormous secrecy that it's impossible to say what really is a convention and what isn't a convention.
In fact, there's a follow-up question to that. It was reported in 2017 that the Collegium decided to upload its recommendations and reasons of recommendations or reasons of rejection or selection of judges. Has this mitigated the absence of transparency criticisms concern?
Yes, so the decision to upload its recommendations and the reasons for recommendations did help to a certain extent. But they've again done away with this. So if you look at the latest batch of appointments, etc., there are no reasons that are prescribed. And the reasons sort of over a period of time started to get more and more terse with each subsequent year. And they've now seemingly done away with it altogether. So it's really appears to function at the whim and the fancy of the collegium, and there is no way to hold them, there is no accountability in this process. Uh, Certainly, reasons would help, but the flip side to that is a reason for a rejection. See, sometimes when a person is nominated for judgeship in India, especially because it's more of a calling where you're called to the bench, let's say, or asked if you'd be interested. It's possible that a lawyer, who was otherwise going about his or her life simply practicing, uh, simply by saying yes to a call for being potentially recommended to the bench, would then have been rejected for some reason or the other. And then for that rejection to be published along with reasons could have some amount of a deleterious impact on their reputation and goodwill. So I think we'll have to marry these things together and try and find some sort of a workable balance, which the 2017 decision had done in terms of uploading reasons for appointments rather than reasons for rejections. But they've done away with it seemingly altogether again.
So in the US, for example, you have a system where to ensure judicial independence, you gave the Supreme Court judges life term. There is, of course, criticism that life terms has outlived its merit, and every state has term limits on their state judiciary.
Right.
You say there is any merit in such a system where, of course, you put the judges through a rigorous selection process where you are answerable to elected representatives, but you ensure independence post-appointment instead of at the time of appointment. Would adopting such a system in India, do you think, allay concerns?
Yeah, the difficulty is, the Constitution provides for these sort of things would require serious constitutional amendments. But look, I think there must be a way in which we can, even in Britain, you have judges who are often serving for short periods of time, who serve for 2 or 3 years, do it as a job, really. It could be lawyers who serve for 2 or 3 years on some court or the other and then get back to practice. It's not something uh, that's unknown to the British judicial system. It's something that we've simply not embraced in India. Even the idea of having retired judges come back to fill vacancies on an ad hoc basis is again not something that we've seen frequently. But there are, I think, very many different kinds of solutions that we must look towards in trying to preserve judicial independence on the one hand and at the same time augment transparency. We have a system today where judges are first appointed as additional judges, right, for 2 years, and then they're made permanent. But almost nobody is not confirmed. Pretty much everyone is confirmed at the end of 2 years. So that might well be a period of where there could be some amount of testing, so to speak, that goes on, but it doesn't happen in practice. Again, there's no. They might as well have make judges permanent right at the outset, the way the system functions.
Right. Now, next question. The Supreme Court struck down the NJAC. This collegium system remains in crisis, and the executive seems to be having the last laugh. If every path leads us to the same imbalance, what is the way forward? How do we escape being on the wrong end of power equation every time? Of course, there's a broad question, but do you see a situation where the Supreme Court actually cedes any territory to the?
No, I don't see that happening at all. But the only way that can happen is if we subsume all of this into our larger political debate in terms of thinking seriously about how the system can be changed. And the NJAC need not be the final answer. There could be other efforts made by Parliament. It perhaps will not happen in the near future, but we'll have to constantly keep speaking about it, writing about it, and keeping the attention on it, because it's something that's hugely relevant to how our democracy functions. And because ultimately the courts decide how the constitution is interpreted. And if we want a truly autonomous and a truly transparent judiciary, the system has to change. And it's not going to change from within. I don't think members of the Collegium are going to wake up one fine day and say that we don't want to do things this way. It'll have to happen uh, through political intervention and through parliamentary intervention. And the time would have to be right for that. And one is hopeful that it will happen. And there's no reason why this government shouldn't do it either. But even if it, but but for that to happen, we need to, sort of ensure that we keep our gaze on these decisions and do not stop thinking about it critically.
Thank you. The next question. The decades-old proposals for an all India judicial service, including the amendment in the midst of the emergency to provide for an all India judicial service, again the proposal floated by the UPA government in 2012, have been struck down as an infringement of their independence. How would you look at the proposal for a new all India judicial service selection process by a Judicial Appointments Commission entirely under the administrative control of the Chief Justice as a method of selecting a certain ratio of judges to the High Courts?
Yeah, look, the All India Judicial Service is broadly for selection of judges at the district judge level. And even now, the manner in which the proposal has been made is towards that. The problems there are concerns about federalism, right? Like in the sense of centralizing this entire process of appointing judges to the subordinate judiciary, in that the states will be ceding control. There are also many other concerns about such a process because I think, for one, knowledge of the vernacular, ensuring that there are judges know the regional languages to which to the concerned judiciary to which they are selected, etc. So the real thinking has been more in terms of selecting the subordinate judiciary. And look, when we speak about independence of the judiciary, independence at the level of the subordinate judiciary is also hugely important. But I think the main concerns are matters of federalism in terms of states losing control. And I think, given a scenario where you already have a tilting of balance in favor of the union, this is perhaps a a path that we don't necessarily need to take. But do we need to think of something along those lines for the appointment of judges to our high courts and the Supreme Court? There's no reason why we must not think along those lines, especially to the high courts. There's no reason why it ought not to be guided by a process of having a test and a subsequent process of interviews and a properly established commission, possibly headed under the administrative control of the CJI, or have a former CJI, etc., on the commission. And one can call it whatever, I think, which is essentially what I meant by a commission-based system of appointing judges. But there are these sort of commissions that function in other jurisdictions, especially the ones that seem to work well in Britain and South Africa, where you have a commission of, say, 15 members, comprising members from the judiciary, from the executive, from civil society. And you have a clearly established criteria. You possibly can have tests followed by interviews and then have a decision-making process.
Right, thank you. Is there a country whose procedure of appointment of judges stands out to you in particular, which could possibly be adopted in India to resolve some of these issues?
Right. I mean, as I was saying, I think Britain and South Africa, both, which have a commission-based system of appointing judges, and the in Britain, and I think the NJAC was sought to be fashioned on this, although it didn't follow the process strictly. Uh, you have a system where you have the highest members of the judiciary on the board or the commission. You have members of the executive, in that case, the chancellor or the chancellor of the exchequer, etc. You could have in India the law minister, etc., be granted a place on the commission. You could have members from the opposition also granted a place on the commission. And you could have members from civil society, could comprise retired judges, retired civil servants, and so forth. And those are so therefore it's not as if this is an unworkable solution. As we discussed right in the beginning of the talk, obviously achieving some sort of perfect separation of powers can be a very difficult task, but there's nothing to suggest that we cannot work towards a workable solution where you have accountability along with independence.
Right. Now, is the appointment process, a moment of appointment or the time of appointment, the only time there is any accountability really? I ask this because when you consider the impeachment process, it is onerous, as you mentioned. You also see High Court judges being transferred. Many times it is only rumored for disciplinary reasons or other reasons. Again, there is complete opacity. We do not know why. So when you consider post-appointment, there's no real way to hold any judge accountable. And what we see in practice is only a system of transfer. And for the Supreme Court, there is not even that. So do you see any other moment where there can be accountability, or is it just the appointment?
I think in our system today, there is no accountability. There simply
Right.
isn't. Yeah.
Okay. Understood.
I mean, there is I can't think of anything which allows for such accountability. The only accountability that is there in the case of a high court judge is you have an appellate process, right? At least on the judicial side, in that
Right.
a judgment delivered by a single judge of a high court is, in many cases, appellable to the division bench of the high court and all the way up to the Supreme Court. But we know that the scope for interference in all of these matters is often limited. But that doesn't mean, so there is judicial accountability at that level, obviously. But in terms of a larger sense of accountability, we do not have a process. We've seen how it's worked in recent times. In terms of the issue with respect to Justice Yashwant Verma. And the flaws in this process are also plainly laid out. I think we've seen how it's played out even in the Supreme Court. And so unless something of that gravity happens, there doesn't seem to be any accountability.
Right. Right. I think we have anyway, I think we are done with the questions. Thank you so much for responding. Thank you so much for the address itself. It was as detailed as your writings, and I'm glad we could have this conversation. Over to you.
Yes, thank you very much, Arun. Thank you, and thank you to the organizers as well.
Thank you all participants. We've had an excellent discussion. Two great exponents of the legal system, Mr. Suhrit Parthasarathy and Mr. Arun Menon. I want to thank them specifically for making this discussion comprehensive and insightful, and for having fielded the questions which covered the entire range in the field. Thank you so much. I have just an announcement. Anekdhara is completing 4 years this month, and next month we are having the first offline seminar in Hyderabad. It's on the theme of rural education and grassroots insights to sustainable pathways. We will, of course, be sharing it with all our subscribers, and we will be live streaming that too. Thank you all. Thank you so much.
Thank you so much. Thank
Yeah,
you.
great. Thanks.
Live streaming ended, sir.
Thank you. Thank you so much.